Always a tough act to follow. Unfortunately, also called this like the hottest show in town, which is always hard to follow in the sense that I'm coming up with statistics, which, as you know, sometimes can be very dry. I'll try to make them lukewarm, but we will see how it goes. I think at the end of the day, though, I want to make the case that these are not just statistics. These are the testament that the court system in Saudi Arabia is not only ready, ripe, mature, but above all respects arbitration and supports arbitration to the very extent. So this presentation today is a continuation of what we did last year, in that we had looked at Court of Appeals judgments, in fact, 520 of those. This year, we also look at Supreme Court judgments and Enforcement Court judgments. Now let's get started with, quickly, the Court of Appeal judgments. We had 520 last time here in Dubai. This year, we looked at another 180 for a total of 720 judgments to understand what's going on in these Saudi courts. We have indexed this into 6 buckets, or 6 categories, if you will. Arbitral tribunals, awards, etc., etc. We will be focused on awards today, and here we have found 256 reasons. Keep that number in mind, please. Now, in the interest of time, we'll skip through this slide here right now. These were the findings from last year. Perhaps the takeaway for today is that the awards were coming in at 32%. This year, the number hasn't quite changed, 30% as well. So we're very comfortable to say that the empirical statistics of the data is sound, because this sample has not much changed from last year. And in fact, if you look at all 720 judgments, the award section, the red piece of pie here, comes in at 31%, which is what we're going to be looking at today. Now, when we come to the so-called motions to annul and to enforce, here this pie of 31% amounts to 256 motions that have been resolved by the Court of Appeals. What is important here to note, perhaps, is that 49% are with addressing enforcement proceedings. That is, the remainder is addressing annulment proceedings. You see on the top right, this amounts to 131 motions, and what we found very interesting to see here is that 92% or 120 have been denied. That is 8% of annulment motions that actually were successful. Not in full, some only in part. So this is a very strong number to showcase that if you file a motion to annul in the Saudi courts, you don't have necessarily a winning case. As a matter of fact, again, remember this number, 8%, very strong number. If you like to believe what you sometimes hear internationally, some will tell you, and it's not a confirmed number, they will tell you that motions to annul internationally, or when you look at averages, amounts up to around about 10%. So faring very well in Saudi Arabia with 8%, under what you otherwise internationally will find. If you want to further drill down, you can even go a step further by saying, well, these are 11 motions in total. If you look at the full amount of 256 motions, you end up at 4%. So again, very strong numbers coming up from Saudi Arabia here. The reasons, to no surprise, you will see here a couple of reasons. We listed them down. We will not have the time to go through all those reasons. But look at the 4th position. That's the ground, the annulment ground, Sharia, public policy. And this goes to show to you that only 24 motions to annul were based on Sharia public policy out of 161. That's just about 9%. So to all those who always believe that Sharia is the main reason why people are scared to go to Saudi courts, think again. It's just 9% of the entire pie. We also looked this year at other reasons on the bottom. They're not codified in law, but areas of interest. For example, improper party representation, Dr. Ahmed mentioned that earlier, but also statutory time periods, which once in a while become an issue also in Saudi Arabia. Now, we looked at the 11 successful annulment grounds. And here we found that only 5 were based on Sharia public policy. Again, another point here to be made, that Sharia is not something to be worried about when you deal with Saudi courts. In fact, when you look at the all over 24 reasons that Sharia has been raised in the Court of Appeals, you will see here that 79% or 19 motions of that kind have been denied. Again, another very strong number that suggests, at least according to the numbers, that Sharia is not something to be scared of. Quite the opposite, and very often you find it in various jurisdictions codified in some way or another. Now, the grounds of Sharia, without going through those, we try to put them up here, and by the way, these slides will not be available. Something better will happen. We'll have a report later on in early 2023, where we will dissect all this. So Don't take snapshots right now. We will have this all in a report for you later on. But these are the reasons that we have found that were of interest. And if you look at those reasons, you find them in your jurisdiction probably as well, except perhaps the first one, interest, later payment charge. That is something, riba, that's something that is very unique perhaps to Sharia, at least the way has been found here in those particular court proceedings. Now, let's move over to enforcement courts. Last year, we limited ourselves to the Court of Appeals. This year went a step further. We have been very fortunate that the Ministry of Justice, upon a couple of times asking in, gave us some empirical data about what the enforcement courts have done in 2021. And to be precise, 2021, January through September. Now, they have given us not only just the statistics, they gave us a quote and from no one less than the Deputy Minister of Enforcement when he said, "No judicial precedents have been found relating to the refusal to enforce a foreign arbitral award associated with the violation of public policy." Again, another testament that foreign awards do not have to be scared, or parties do not have to be scared about Sharia being something that may impede the enforcement of your otherwise foreign award in Saudi Arabia. Now, quick facts. I mentioned earlier the time frame, January through September 2021. We're hoping to get the rest as well. Enforcement of 522 local and international foreign awards, 12 foreign awards as a matter of fact. And the 12 foreign awards came up to 33.6 million in terms of amount. On the bottom, you see the 6 countries. Each has seen 2 foreign awards. We're looking at Morocco, Lebanon, the UK, South Korea, Switzerland, and the UAE, of course. Now, on the right side, you see, of course, the laws that you're very familiar with, Saudi arbitration law for the locals. And, of course, for foreign awards, you look at the New York Convention in order to get your case enforced or not. Now, more statistics here, if you will. Again, foreign awards, 12 statistically. What was interesting to see on the bottom right, we looked also as to how much the money that was involved here. You see exponentially more value in the foreign awards being enforced. It comes naturally, usually in foreign infrastructure businesses come with a higher price tag. So that would explain probably why the foreign awards are higher in amount. Now, Supreme Courts, that is very new. We're very happy that we could also put our hands on some of the Supreme Court judgments, which is something that is not so common. And it is very hard to find, so it took a lot of arm pulling to get actually this data in. I cannot thank enough our CEO, Dr. Hamid Mera, for making the impossible possible to get us this data. Very interesting things happened here as well. We have tried first to understand for you as well, it's very simple in the end, what gets actually to the Supreme Court. And Article 50.1 is very clear here. It makes clear that the competent court, if it enforces the award, that's the end of the inquiry. There's no appeal. However, if the competent court, for example, the Riyadh Court of Appeals, does nullify or annul the award, then you have to have the opportunity within 30 days to go to the Supreme Court and try to change that by way of appeal. Article 17 of the implementing regulations makes very clear that the competent court we're talking about here is actually the Supreme Court, so there's no question about this. Now, the next slide, you might probably ask me here when we looked at 38 Supreme Court judgments, why are 29 related to annulment and enforcement? Well, I don't have an answer to this. People try strange things sometimes, but indeed there have been also attempts to get the awards annulled when they already were enforced in the lower instance, which of course is something that goes against the jurisdiction of the Supreme Court. On the right bottom side, you see in fact that out of the 29 judgments, 4 made the smell test of jurisdiction, Article 51.2, 3 were denied later on the subject matter, and 1 was granted. And here are the 3 that we have seen. To no surprise, these resemble the reasons that you find in Article 50 and 55. The first one, in all cases, the Supreme Court sided with the Court of Appeals. The first case, this was based on Article 50.1g. In short, an award can be annulled, of course, if the tribunal, in that case, fails to observe the conditions required for the award, obviously as to affect substance, or otherwise the award is based on void arbitration proceedings that affect it. That was the first case. The second was about 55.2c. Here the issue was that the award was not even properly sent to the responding side. Obviously it was annulled, and the Supreme Court said, yes, absolutely. If the other side doesn't even know this award exists, how can you enforce it? And the third one is Article 50.1f, where also very common ground, the Supreme Court sided with the Court of Appeals by saying, well, what you have decided is not contemplated by the arbitration agreement and or out of scope. So again, here the annulment was confirmed. The one case that actually made the cut, that survived the scrutiny of the Supreme Court and eventually got remanded back to the Court of Appeals, is a peculiarity in that the plaintiff limited himself to the analysis of Article 55.1. 55.1 essentially tries to explain when an order to execute, an order to enforce can be granted. The first reason here clearly is that it should not be in conflict with an existing judgment of a court or similar. Second one, Sharia public policy, no surprise there. And thirdly, again, you must inform the other side that the award exists, notification. In that case, again, the Supreme Court sided with the plaintiff and remanded it to the Court of Appeals, and we will hopefully soon find out what happens next. Now, areas of interest. These are the awards, these are the judgments from the three respective courts. We also try to see whether we can bring to you some areas of interest. And a short summary, last year we had 5 big takeaways. I'll just put them up here again one more time. I think most importantly to mention here, Article 50.1 enlists the ground for annulment, and the courts have strictly and consistently applied those grounds. That is, in other words, very often plaintiffs have tried to argue an argument that did not exist in the law, and hence this Court of Appeals obviously has stricken that down to say, if it's not in 50.1 or Article 50.2, Sharia, then you cannot argue it. It's not a ground that allows you to ask this court to set aside, annul, or nullify the award. Other big takeaway was Article 50.4. It goes without saying, but we have seen this very often, that parties try to persuade the Court of Appeals to re-argue the argument. In other words, they essentially appeal the award and try to get the Court of Appeals to essentially redecide the facts in the subject matter. And that's a no-no. It's Article 50.4, very clearly and consistently applied throughout all court proceedings and court judgments we have seen. You cannot do that, which is very warming. Success rate 6%, and otherwise the competence, and severability doctrines have been also fulfilled to the extent as we know it. Now, what's new, what's interesting? I mentioned earlier statutory periods. The 12-month period of Article 40 is a little bit of an eyesore in the sense that we have seen that bubbling up in SCCA cases, but also other institutional cases. Article 40.1 is essentially about that parties can agree on a timeline or a time period or an arbitration period. If they don't do so, the law provides, particularly in ad hoc cases, very important, as I would say, that the arbitration shall terminate in 12 months. You have to be done in 12 months. Article 40.3 then allows a party to go to the court, in this case the Court of Appeals, to have them terminate the arbitration if it exceeds 12 months, or extend for that matter. Article 40.2 says that an extension can be given by the arbitral tribunal up to 6 months. So it's very important. Article 40.4, that is another additional month if you have a substitute arbitrator. It's not something we see very often. So that's the background to what happens here. Perhaps 5 cases on point that really drill down and bring home the argument that this is something that is important, well-intended 12-month period, but this is not an absolute right. In fact, right away, the first judgment has made very clear in 2018 in the Court of Dammam, Appeal Court of Dammam, that you can not just make this an absolute element. In fact, what happened here is the arbitral tribunal needed an expert. The party actually that caused the delay by not paying the deposit for the expert is the one that later on went to the Court of Appeals saying, you shall please annul the award because now it's delayed. The court, of course, said, well, A, you were the reason why this actually got beyond 12 months. And B, if we do this, we would kind of solicit essentially the breach of an arbitration agreement by allowing a party to cause the issue that later on leads to the termination of the arbitration. That cannot be the answer. That was the first case. Second case, the court made clear that the tribunal, the arbitral tribunal, is not limited to give extensions to the original 12 months. What happened in that case, 12 months passed, the parties had actually agreed to, I think, up to 3 or 4 extensions, and then there was still not enough time to get it done. The arbitral tribunal then extended in accordance with 40.3, and that was okay according to the court. Okay, it's not connected to the original 12 months. The third case kind of goes without saying, but it's good to hear it and see it also in case law. The competent court can, of course, extend Article 40.3, the arbitration period, and is not limited in any shape or form. Article 40.2 is for arbitrators, 6 months. Article 40.3 is for courts, no limitations. And then finally, we have also 2 more other cases which were of interest. Again, it goes without saying, the 4th one here, the tribunal can extend, but does not have to consult necessarily the parties. Of course, it's good practice to do so, but it doesn't have to. In fact, in that case, the respondent was even arguing, I didn't approve the extension, so it should not be allowed. Of course, the court said, your approval, A, is not needed, and B, the tribunal has the ability to conduct the arbitrations as they deem appropriate, including not consulting the parties and giving themselves an extension. So that is okay. But the last case here in this list perhaps reminds us that this is still something to be taken serious. In that case, the arbitrator wasn't quite doing much. 12 months had passed. And so here the Court of Appeals sided with the plaintiff, the arbitration respondent, and said, okay, fine, 12 months have passed, we'll terminate. And that's then the end of that arbitration. So very interesting, Article 40. Keep an eye on this one. I think this is important. Final thought, food for thought, not a legal opinion, not legal advice, not necessarily SCCA's opinion either, but the question is, when you agree to institutional rules, like the SCCA rules, would you then not replace the regime, which is dispositive, Article 40 says, the first line, Article 40.1, which is dispositive, would you then not replace Article 40 in its entirety with the institutional rules? Think about it. In my humble opinion, you do, but this is something that we still need some more clarification. Hopefully one of those cases will soon go to the courts as well, so we can at least show you to this next year. Now, another interesting point that Dr. Hamid mentioned earlier, party representation. This has been also an issue that bubbles up in many jurisdictions, but also in Saudi Arabia. And we have done, we moved mountains to actually get clarification on this. We had a study on this in cooperation with the Ministry of Justice. And the output eventually was that you have party autonomy to be represented by whoever you want, including foreign counsel. And we have seen those cases at SCCA as well. So there's finally some clarity on this. Not only that, the Ministry of Justice was so kind to also give us a letter that you see here in small on the right side. Essentially says that even if that were a ground, it's not one under Article 50.1. In other words, you cannot get the award annulled because the other side had foreign party representation. And in fact, one case on point we found here is from 2021, so just last year. Here the court had to grapple with a plaintiff arbitration respondent who essentially argued that the arbitration claimant, in that case here the defendant, had violated Article 3 of the Saudi Code of Law Practice. Saudi Code of Law Practice, Article 3 says, got to be national and you've got to be registered with the Saudi Bar Association. That counsel was neither, but the court here again essentially said, even earlier than what this letter already says, it's not a ground under Article 50 and you cannot get an award annulled based on that alone. So very promising information here and very happy that we could put that one to rest because this has been a really bit of an eyesore and you just don't need this sideshow when you already have other things to worry about in arbitration, particularly not at the early stages. Now, third of 4, we have also seen various cases. In fact, of the 814 grounds, 411 pertained to arbitral tribunals, mostly to appoint arbitrators where parties just couldn't get it done. And here it is suffice to say that Article 15 gives the Court of Appeal the ability to appoint the arbitrator upon party request in ad hoc cases, of course. Now, that takes time. I just read the other day an article about India. I think it takes them 6 months to get an arbitrator appointed. We're trying to do better. In fact, what we did in 2019, in November, we introduced something called the nomination service, or arbitrator nomination service, and that assists the court system, and particularly the Court of Appeals, to identify arbitrators drawn from our roster. And essentially what happens, the court comes to us, they tell us the criteria, we search our roster, we nominate, that is, we propose candidates. We don't appoint, we propose candidates, and then the court looks at the names, we pre-vet for the big interest issues or conflicts, and then the court appoints the arbitrator. We do this in 2 days, 2 business days. We have done, as of yesterday, 112 of those cases, and it has been a very promising support system for the court system, and we do this free of charge at the moment. So very promising. 4 examples here across the bench. It's usually the respondent's party-appointed arbitrator that is not appointed, so the court has to jump in, we help. Or it's the presiding arbitrator because the 2 party-appointed arbitrators failed, or the parties in turn failed to select the chairperson, that is the presiding arbitrator. Again, here we have helped in all those scenarios. These are just 4 that hit the docket and have just been decided, where SCCA has officially mentioned. Final point, that right to ask the Court of Appeals to appoint an arbitrator is not absolute either. We just looked at Article 15. The courts are very reluctant and usually reject motions to appoint an arbitrator if and when the parties actually have agreed on the selection mechanism or to the appointing authority. And that was an interesting case we saw here in this year, where essentially the parties had breached, or one party had breached an architecture and interior design agreement in a very prominent area in Jeddah. And what happened eventually is the parties were unable to agree on the sole arbitrator. And I'll skip a couple of steps, fast forward. The claimant went to the Permanent Court of Arbitration in The Hague, because this was under the UNCITRAL rules, UNCITRAL arbitration rules. And the PCA has 2 options. Either they appoint the arbitrator or they designate the appointing authority. In this case, the latter occurred. And that was us. That was the SCCA. Very humbled about that. And we appointed the arbitrator in short order. And the case was decided, an award was rendered and issued. And then it bubbled up again in the Court of Appeals, here in this case in Riyadh. Now, the interesting part here was the plaintiff, the arbitration respondent, was making 3 interesting arguments here. The first one being, of course, that there was an issue with the way the arbitrator was appointed. Essentially, the plaintiff argued Saudi arbitration law was applicable. That's not true. The contract was very clear about saying UNCITRAL arbitration law. The second point was that the arbitrator did not have the university degree or Sharia, which is a requirement in Saudi Arabia for at least sole arbitrators under Article 14.2. That is not true. The arbitrator we appointed was an international arbitrator residing in Saudi Arabia. And the third point, that the respondent was not even notified of the appointment. I can vouch for it because I wrote the letter myself. So all those points had failed in court, and the court again ensured that this was not a ground for the award to be annulled. And with that, I hope I was able to keep that nuke warm in terms of statistics. Apologies for the delay, by the way. We try our best to catch up a little bit, but we will probably have to expedite also the coffee drinking a little bit. At least I was told to give that announcement. And with that, thank you for your attention.